Bangladesh, learned Barrister Azmalul Hossain, Queen's Counsel, and other learned speakers. Good afternoon, and viewers as well. Assalamu alaikum. To begin with, I confirm that my discussions shall not include any sub judice matter and are purely based on contemporary information. And my limited knowledge and the limited experience that I would like to share during these difficult times, I have segregated it in a general comment, observation, and some humble suggestions to the Honorable and the learned panels. I was hearing this Barrister Masum very elaborate in his opening statements and remarks. He has almost covered the contemporary affairs globally and locally, which is very enterprising. But we have some views that we would like to highlight and get some comments from the learned panel on the matter, so to ease the future for banking and for the industry at large. In cases, we have read at times and experienced that formal justice system in Bangladesh can be lengthy and at times inaccessible to those who need the most for multiple reasons. At an outset, the lengthy trial periods and implementation of court decisions becomes challenging. And in most cases, banks get included in litigations, as we all know, due to violations of contracts with clients for non-payment of loans, fraud, and related complaints, and vice versa. As you all know, recently the closure of courts due to the pandemic were also challenging for banks because cases against default clients remain pending. And that is one of our core strength and core revenue vertical. However, the virtual court system in Bangladesh under the use of information and communication technology by Courts Ordinance 2020 has resumed the adjudication processes. But still, we anticipate this may delay the disposal of cases and may further cause a backlog. So that is a general overall comment, and we have some observations that we understand. It's from a layman perspective that virtual court allows new cases to be filed. However, at times pending cases may remain unresolved. We can give example on money loan suits and some NIX, as well as Barrister Masum had highlighted in his statement earlier. Also, we heard that cases are stuck and awaiting court transfer for ownership certificates for mortgage property, which is a major risk mitigating factor for a bank, because that's one of our high prioritized collateral. Also, obtaining a certified copy of judgment from the court is at times unavailable. Hence, completion of the title transfer process remains incomplete. At times in cases, and I have a first-hand experience on this, our counsels and representatives were unable to pursue a police warrant execution as warrant copy never reached the police station on time. And we had been very vocal in the press and in public on potential defaulters, that we prosecuted them on Negotiable Instruments Act, and the warrant copy of the warrant never reached the police station on time, and hence we faced multiple challenges. Also, in the scenario of the virtual court, as Mr. Masum had given us a good news that 100 million people now can access. But however, having said that, technological challenges can lead to an interrupted hearing and the reach to the general people who are actually justice seekers. And even though both the divisions of the Honorable Supreme Court of Bangladesh has new practice directives, but in reality, the courts perhaps were possibly hearing bail petitions. We have participated in sessions as well for our own interest, but I'm sure that has improved now. So the limited scale operation of the virtual courts may become a bottleneck for trying to enforce basic right to the administration of the law and justice overall. And also that can affect banks, leading to a monetary consequences. Now, this is a chapter that I am highlighting to the fact representing the industry, But I'm sure the situations and the issues can be unique. It can be in a differential method. Now, we understand that access to justice is a fundamental for ensuring rule of law. And therefore, the initiative of virtual courts with limited resources and digital infrastructure is, of course, praiseworthy. And the initiatives that the Judiciary Department has taken to expedite the processes of concluding pending cases are remarkable. And I'm sure once upon a time, perhaps in 1982 or 83, if I remember clearly, there was a case conducted in an appellate court of Bangladesh stating that the court would agree video footage as evidences, and here we are today doing video conferencing on webinar. So I'm sure we have progressed in multiple avenues that has brought us to this crossroads as new normal. Now we understand that we will have to perhaps accept to this new normal scenario till such time that we see physical judges and physical practitioners appearing and arguing the way forward to get justice. Also, amendments to relevant laws has become critical to allow video conferencing to help record witness statements for both regular and virtual courts. That's perhaps a consideration the learned panel may wish to review. Also, the virtual court is already in practice in neighboring countries, as Mr. Masum has rightfully said, and that have been proving record of accelerating in litigation processes. So I'm sure that would really assist the backlog to conclude at as soon as possible time. Finally, we believe a legal framework for virtual courts may need provisions for electronic documentation, incorporation of e-payment fees, virtual affidavits with digital signatures, and issuing certified digital copies of the judgments and judicial orders. So I'm sure once perhaps we are in the process of doing such, but once this takes pace, I'm sure for litigants and for practitioners and for the honorable judges, things would fall in much smoother and much easier and much desirable and understandable in the profession and in the practices of the judiciary to cater to the people of the country at large. Thank you so much again for inviting me. I hope I was able to highlight some facts that are in practice and the scenario at this time. Thank you.
Sir, in this aspect, we would like to know a question from you, how you are going to explain about it. That is, the virtual court system has emerged worldwide, but it has technically increased the questions of data protection, whether the process can keep information and documents in confidentiality or not. In that aspect, we want to know, are the banks satisfied with this process, or are there any requirements as a bank, as an institution, prefers the virtual courts to give relief to the litigant public?
However, you are not audible in the last part of the question, but I understood. I understood the question. Thank you, Advocate Asma Hamid. Now, see, all these scenarios that are approaching now and in the post-COVID situation are basically, everything is based on assumptions. And everything is new to us and new to the system. However, data integrity and the protection of data is a primary concern, I'm sure not to the banks only, but to every system or every facilitator, including the judiciary, including the courts. Now, that will have to be addressed perhaps at a very serious level, at a different level where there would be integrity managed and maintained in the data, because we are dealing with a mass situation here, with a mass scenario of cases pending and upcoming cases and litigation processes in the courts. So confidentiality of clients, confidentiality of the banking information and data would require to be at a high priority. I am not quite confident how prepared we are to address that issue at this time, but I'm sure there has to have some kind of mechanism to ensure that the data, the storage of data, the protection of the data would have to be accountable. Somebody will have to be accountable, and responsibility will have to be delegated under the system. And I'm sure the Honorable Court and courts will also give some guidance and enlighten their either beneficiaries or the petitioners or whoever, to ensure that the integrity of the data and the custody of the data are kept in confidence and in safety. So as I said, basically, we are all new into this scenario. We are learning every day. I'm sure there will be casualties and consequences, but I'm sure we'll learn and do accordingly over time.
Thank you so much, sir. In the same footing, again, I would like to know from you that with an abrupt concept of introducing virtual court system itself is a challenging issue. So we all wants to know that as a litigant party, are banks facing with challenges? And if so, what are they and how they are overcoming with those challenges?
Thank you, Advocate Hamid. I have responded that on the observations and general comment. In the part of the virtual courts, at times it can go backlog. As you are aware that we have multiple pending cases in money loan and in NI Act and on various forms, starting from the lower court to the apex courts. And as is, I'm not sure if I should be making this comment, as is the conclusion of the certain verdicts and conclusion of multiple verdicts has been pending. And this has been a challenge over the years in the country. And many development steps has been taken by the judiciary and the government at large. And I'm sure all legal counsel are fully aware of the fact that we are a very highly populated country with a lot of issues. And there would always be issues in the society. So that's an ongoing process. Now, in the consequences of the pandemic and post-pandemic, as this is a very unique situation, I think we all are trying to get back to the normal scenario or catch up with all the pendings in whichever best possible we can. So yes, we do have the challenges, and I'm sure the industry at large are facing difficulties in mitigating factors from the judiciary, but we can only do so much because we are dependent on the courts and the honorable judges and the system at large to mitigate and to conclude the pending hearings that perhaps has been pending for a while. In every scenario, as you know, that we look up to the court all the time. Once our contracts are at stake, when our contracts are breached and violated by a potential defaulter, or in similar methods, in fraud or whatever. So whenever those occurs, we give that a priority for us to ensure that we are getting the favorable verdicts from the courts to ensure that the money for the bank is returned from the defaulters, because as you know, we deal with public money, and we are accountable to the people of the country. We are public servants also, because we are the custodian of public funds. So we have a moral obligation. It's a regulation and obligation that every banker has to follow. So whenever there is a breach from consequences, we would like that to be resolved at soonest. So definitely, when there is a new scenario happening through virtual ends where hearings and proceedings are limited, definitely there is a question and concern from our end, because our dependencies are immense. So as you know that, yes, we do have faced challenges and difficulties, but I'm sure consequences, the situations will improve, and the courts will go back to a normal scenario. But I'm sure a parallel practice between virtual and regular courts can be the future, because today we have the pandemic, tomorrow there could be something else, and there could be cost efficiencies, mitigating pending cases on a very fast track. everything can contribute to a virtual scenario as well. So I think that is, we will have to take it as it goes. But humbly, we would